Okay, good afternoon everyone. Welcome to the session Expertise Can Strengthen Cyber Resilience. My name is Patrick Pawlak. I'm a visiting scholar at Carnegie Europe and I will be the moderator of this session. But before we start, I'd like to thank the governments of the Netherlands, Canada and Costa Rica for kindly agreeing to be the co-leads for this session and putting this wonderful panel together. I think that once again shows the leadership of these countries in the conversation about international law in cyberspace. But today we're going to give you hopefully a slightly different take on those conversations than we normally hear about at the United Nations. Without further ado, I'd like to give the floor first to Ambassador Ernst Norman, who is Ambassador at Large for Cyber Affairs from the Ministry of Foreign Affairs of the Netherlands, who will welcome us all on behalf of the leads, and then we'll switch and move to the panel. So, Ambassador, here you go.
Thank you very much, Patrick. If I look at the title, I can't help to think of Dutch farmers who are usually leveling the field with a laser beam to make it even flatter than our country already is. But it's not about that topic today. I want really to thank you for joining us for this important session today. The Netherlands is glad to partner with Canada and Costa Rica to discuss how international law expertise can strengthen cyber resilience. Where the internet started out as a new way for academics to quickly exchange ideas, it has grown to become central to everything we do. Not only as persons, but also as societies, and of course as economies. The World Economic Forum estimates that 70% of new value created over the coming decade will be based on digitally enabled business models. 70%. In other words, the stakes have become incredibly high. And to protect our people and harness our interest in this interconnected and vulnerable domain, the rule of law is of vital importance. Principles of international law, such as sovereignty and non-interference, are key to protect our critical infrastructure and to ensure the independence of our political systems. With this in mind, states have come together at the UN and recognized that international law applies to cyberspace. This is a key ingredient in promoting stability and security in cyberspace and harness the potential of cyber for the development of states. Today, conversations in the international community around this topic evolve around the question how specific rules apply. These discussions are an essential step to common understandings on what is and what isn't allowed in cyberspace. These common understandings can in that way serve as rules of the road for creating a more open, secure and safe cyberspace. As cyberspace is a global common understandings need to be agreed by as many states as possible. It's essential that we share our insights and interpretations and discuss and agree these in broad multilateral contexts through an inclusive and transparent process. Legal capacity building is essential to be able to contribute and participate in achieving these common understandings. That is why the Netherlands prioritizes this particular type of capacity building. Today, we're not going to delve into complex legal discussions, panelists. Rather, we zoom into the question on what countries can concretely gain from increasing understanding on how international law applies in cyberspace. In other words, why should states increase their legal capacities? And what can a better understanding of the application of international law bring to the national level in terms of development of national and international cyber policies and strategies? What does a better understanding of international law mean for cyber resilience? Can it strengthen national attribution procedures? I am certain that our speakers today will shed light on these timely and important questions. Again, thank you very much for joining us, and I look forward to a fruitful discussion. Thank you.
Thank you, Ambassador. So, as you have heard, it's not going to be about international law, but let's see. It's not going to be about the details of international law, so I'm warning the legal scholars on the panel, but we will still want to tease your brains a bit when it comes to specific provisions. As I've mentioned in the opening, the discussions about the application of international law is really usually put in this box of international security. So the questions and the answers that we ask and give when it comes to international law are also framed from the international security perspective. But there is, however, another dimension that has not really been explored, and I hope that this is what we're going to do with this panel, which concerns the link between international law, but also with development, which is the theme of the conference itself. How can we create the connections between international security, cyber resilience, and international development? So exploring this dimension and the connection between international law and development is something that I hope we will be able to do as well today. Think how international law has impacted development agenda when it comes to environmental standards, civil and political rights, open and fair trade, or the fight against international crime. None of those fields would actually contribute to development if this was not for international law and the treaties that we have in place. They have provided certain standards that states had to abide by. So in other words, there can be no sustainable development without international law, I would argue. There can be no sustainable development without cyber resilience. And there can be no sustainable development without international law in cyberspace. And I think that's something that we will clearly demonstrate with the discussion. To dive into those questions and explore them in more details, we have a wonderful panel. Ambassador Norman, you've already met in his opening remarks. Then we have Ambassador Ricardo Torola, who is another co-lead and host of the session, who is a senior advisor to the Vice Minister of Foreign Affairs and Worship of Costa Rica, and provides legal support during the decision-making processes in a wide range of subjects, such as security, migration, and human rights. Our other co-lead for this session is Canada, Christian Ranger, who leads the operations of Canadian cyber diplomacy, is a career diplomat, but also an economist by training. So not mix you see very often in cyber diplomacy. Joining us on the panel are as well Cristina Leila Nisale, who is the Deputy Permanent Representative of the Philippines in Geneva, so representing the Philippines to the international organizations based there. Nena Ifenio Ajufo, who is chair of the Global Forum of Cyber Expertise Working Group on Cybercrime, participates in the work of the Working Group on Cybersecurity of the African Union, but is also a professor of law at Leeds Law School, Leeds Beckett University in the United Kingdom. And last but not least, Liz Vihul, who is the founder and chief executive officer of Cyber Law International, a firm that provides international cyber law training and consulting services to governments and international organizations worldwide. So if you've heard about cyber capacity building when it comes to international law, Liz probably was one of those people who you have heard of delivering the trainings. So without further ado, I'd like to jump directly to the questions and the discussion that we would like to have moving forward. And I'd like to start with a very practical example. And Ricardo, I'm looking towards you. Costa Rica in 2022 has suffered a significant ransomware attack, after which it has announced a national emergency. The case has been raised and discussed at the United Nations Open-Ended Working Group at different side events and in the plenary many times. Recently, Costa Rica has also published its position on the application of international law in cyberspace. Why? Why developing a position on international law become part of the solution for strengthening cyber resilience and promoting growth of Costa Rica? Could you give us examples of the real impact, how thinking about international law has exactly changed also the perception within your country about how we should be approaching cyber resilience and how international law is part of the answer? The floor is yours.
Thank you very much, and thank you all for being here today. I would like first to give a little bit of context to those who maybe don't know. Costa Rica is a small country in Central America that abolished its army in 1948. Tomorrow we'll be celebrating the 27th anniversary of that occasion that made the country, gave the country its identity as a peaceful country with peaceful and friendly inhabitants, but also a country that depends on international law and the multilateral system in order to defend its sovereignty and its territorial integrity. In that context, to be the target of the attacks that occur in 2022, in April 2022, was a complete surprise for Costa Ricans. We always thought we were a small country, we don't have any issues with any other countries. How anyone could think in attacking our infrastructure. So it was a complete surprise. And it was an attack, well planned, I think, in the sense that it targeted key infrastructure, key institutions that had a very damaging effect on our economy. For example, one of the first institutions attacked was the Ministry of Finance. So all of a sudden, we didn't have the systems that allowed our exports and imports to come in and out. And the other key institution that was attacked was the healthcare system. That Costa Rica has a one provider healthcare system where everybody has universal access to healthcare, and that was also targeted. A couple of years before that institution, la Caja Costarricense del Seguro Social, the healthcare fund, had moved all their physical files to electronic ones. So all their patients have its unique medical file online. And that was also targeted, and all of a sudden, all that work, it just didn't, it wasn't online anymore. So we could see running doctors in the hospitals trying to find the paper files that allowed them to give proper care to their patients. So that was very impactful. Almost 20 institutions were affected by the attacks. Nine or 10 of them were seriously affected, including those that I mentioned, but also the payroll system of the Ministry of Education that made tens of thousands of teachers having to work without paid for almost 2 months and until those systems were restored. So at the end, we spent 3 months trying to bring functionality back to all those systems, and one more month to make them all completely restored and bring them, having all the information back. The two organizations that is, I think it's really one that claim responsibility for the attacks were Conti and Hive. Their modus operandi normally is with ransomware. They requested a ransom of $20 million to be able to restore the documents. Of course, the government didn't pay that, and legally we wouldn't be allowed to do that either. But to be sincere, these attacks caught us off guard. At the end, at that moment, our CERT in Costa Rica had only 3 people covering all the cyber incidents in the whole government. And that, of course, we realized it was a big mistake. When the emergency was declared, it was a new government, and I say that's one of the reasons I think it was a well-planned attack, because it was made during the transition period between the end of an administration and the start of another. So it made a lot of people really worried that it was the prelude of something else. At the end, it was just the attacks, and it was an attack for profit, but it had a very impactful end. We spent around $25 million to restore all the systems between the infrastructure and the software needed to do that. And also, at the end, we managed to value most of the damages in $200 million that were lost in revenue by the tax collection system, and also in production, because since the export and import system was not in line, we took a long time to move back to the old form system that you used 20 years ago in order to be able to export our products, and many products were lost in the process. So it had a very negative effect on our productive system, our productive sector. I think we learned from that lesson. From then on, it triggered a government-wide reaction, and we engaged with our friends, our countries that work with us normally, for example, the United States, Spain, Canada, Israel. They all came and bring us the necessary tools and advice of how to best recover from those attacks. And that's a first important lesson, that we need to keep engaged with our partners, and especially the ones that are a little bit ahead in this field. But coming to the international law, one of the things that we noticed is that the legal framework to go after these organizations was really loose. And we started to work in several key areas. One of those was the national position regarding the application of international law to cyberspace. And at the end, it was concluded that, as many other countries have think about this, that the international law applies in its entirety to cyberspace. And I think we issued a very ambitious document, in the sense that it covers not only the usual subjects like sovereignty, international wrongful acts, aggression, things like that, but also human rights and international humanitarian law. It was a very interesting process because we engaged with a lot of international organizations, with ONGs, to bring inputs and create a document that was very wide and comprehensive. Just to end, I would like to say that we think that this will impact our cyber resilience and the growth of our country, because with clearer rules, more stable, well, our production won't be affected because our systems are down, or our workers won't have the healthcare that they need. It brings a more secure environment for investors, but also help us to engage with our friends and international organizations in a way that provide us with their expertise and bring more, how can I put it, bring a a better of the understanding of the situation globally. So in general, I'm sure it will have a very positive event and a result. So I think the effort will pay off at the end. Thank you.
Great. Thank you. I think you made several important points for the audience in this room and those watching us online. Namely, it doesn't really matter whether you think that you're a small country that nobody really cares about. Sooner or later, you might be on the map of potential attackers for reason A, B, C, D. And you do not have to be a big player in order to attract that attention, right? Because many of those attacks are very often opportunistic, and that was exactly the case of Costa Rica. But you also pointed out two important things when it comes to legal framework, and I think this is something that maybe should be one of the main messages from the discussion, the conversation, that A, sometimes the international law doesn't always give us all the answers, at least not the parts of the conversation that we're having, and you pointed out to the question, how do we deal with non-state actors on the basis of international law that actually are not necessarily subject to international law, right, which concerns the states most of the time. So maybe we have to switch a bit the perspective in how we talk about those topics. But the second point you also made about the climate for investment. So this link between international law and economic growth that frankly we also do not really hear very often about, right? We hear most of the time about the impact of cyber attacks and the lack of the international legal framework on the security environment and stability of cyberspace, but do not talk about the economic impact often enough. So these are the great point. And finally, you also have actually told us that it is possible to put the numerical value on the cost of those attacks, which potentially then opens another legal discussion about compensations, for instance, right, in the basis of international. So a lot of interesting questions also of the legal nature, so I'm afraid that we may not be able to avoid completely diving into some of those aspects with our international lawyers on the panel, but this was the great starting point. Christian, I'll switch to you right now, and we all know that Canada is one of the countries that actually has been investing in increasing cyber capacities when it comes to raising awareness, development of legal frameworks in the context of international law. So from the donor perspective, what motivates you? Why do countries, what do countries gain from developing those capacities? What does Canada think it can achieve by investing in those legal frameworks? Because of course I imagine whenever you present the budgets to your political masters, they always need to come with a very concrete justification of what that leads to. So what do you tell them?
Thank you, Patrick. Great to be here. Thank you for that presentation, Ambassador. It's a bit of a cold shower, you know, to hear the story of Costa Rica and everything that happened. But I'm glad that you're taking the lessons to heart. We identified the opportunity to really get into this space of international law capacity building shortly after the first open-ended working group. And Patrick, you mentioned it as a donor, but it's more like a peer, really, because we're in this together. And I'll build a little bit on what Ambassador Norman was saying. The agreement at the UN is that international law applies to cyberspace. It's not how. And I'll get a tiny bit fancy on legalities, even though I'm not a lawyer, just to say that how it applies is built through jurisprudence, And cyber is this strange domain where most of it is invisible. So you don't see the actions, you don't see the reactions, and therefore describing how people are thinking about international law is really hard unless they tell you. And so when countries step up, take the pen and produce a declaration or a speech on international law, then it builds the jurisprudence. So the choice, I think, for all of us is between staying silent and letting other people build that jurisprudence or actively contributing. And I realize this may seem like a strange and a little bit pie-in-the-sky investment. If you're debating between pressing needs, I totally get it. But it is worth it. And I think, what we've just heard from Costa Rica is a good one, a good example. In terms of what can countries gain, I think adversaries take notice. I mean, they do. Whether it's cyber criminals or even states, we see them shift their behavior in cyber every year. And what we think they are reacting to is, the risk of being called out, the risk reputational to them, the risk of states deciding to impose countermeasures if a certain action is found to be in violation of international law. So they do react, and it matters. I mean, we've heard numbers throughout this conference about the huge impact of cyber incidents, whether it's criminal or state-based, on economies. And the goal is never going to be that the goal can be, but realistically, we're never going to get to a place where there are no malicious cyber actors or actions. But even a reduction of 5%, 10%, is huge. And so if you think that, yes, it does matter, adversaries take note and react, and the impact is material, I think that's a big encouragement for everybody to work on this topic. So thank you.
Great, thank you. They do take note when you act and create the environment that is sort of limiting their capacities, right? But they also take the note when you do nothing, and they realize that actually this is quite a conducive environment to perform any activities. So that's a great point. I'd like to bring to the discussion Christine. So when we talk about the application of international building capacity in the context of international, very often everybody's mind goes directly into thinking, oh, does the country have a national position on the application of international law? To some extent, this has become the measure of whether the country thinks about international law and applies it. But I think this is a very limited understanding, and I hope you can help us unpack this a bit. I mean, the Philippines does not have the position on the application of international law, as far as I know. But does that mean that the Philippines doesn't think about the application of international law in cyberspace? In other words, how do states that don't necessarily have those positions incorporate thinking and the discussion that we are having into their preparedness, response mechanisms, and so on? So over to you, Christine. Let me give you this one, and I'll work on this one in the meantime.
Okay. Good afternoon, everyone. Okay, so that was loud. Okay, thank you, Patrick. Actually, I'm very glad that you posed this question because while it's true that the Philippines does not have a cybersecurity law, we are actually in the process of creating one. But the Philippine position actually is that international law, and Christian sort of mentioned this, the Philippine position is that international law, including international humanitarian law, applies to cybersecurity. So, and our application of international law may not be too obvious yet, but it is actually done through several ways, like through international treaties and agreements, because obviously we are also a party to the Budapest Convention. So obviously we adhere to that convention, and of course we are a member of the UN. So any mechanism or dialogue there on pertaining to cybersecurity is something that we adhere to. And the Philippines actually is a top destination for business process outsourcing. So some European laws apply to us. Example is the EU's GDPR, and as well as the Cybersecurity Act of 2019 of EU, because there are some European companies that outsource their businesses in the Philippines, and they impose security requirements. Strict security requirements of European companies that includes that their ICT supply chain will also apply to the Philippines. So these laws actually apply to the Philippines. We, of course, also have our own domestic legislation. Right now, what we have is a Cybercrime Prevention Act, which is a significant piece of legislation that criminalizes cybercrime, which includes hacking, online fraud, and identity theft. I noted, though, that this Cybercrime Act is mainly, although it's not really focused on cybersecurity per se, it's really more on penalizing criminal crimes, but it still applies international law to it. It's just not, probably when you read the law, it doesn't really attribute much to international law, but still international law is still attributed to that Cybersecurity Act. Of course, we also have a government agency such as the National Privacy Commission. While it does not exclusively focus on cybersecurity, it does protect the general, it's like the EU GDPR, so it protects the data privacy of individuals in the Philippines. We also have done as cybersecurity strategies. Right now, we have just come out with the final draft of the National Cybersecurity Plan for 2023 to 2028. This is actually a second iteration of the first plan, which ended in 2022. The first plan really established a mechanism for us, a national computer emergency response team. So it focused on the reporting mechanism, but obviously it now had to be developed. So there's a second plan which already had its final draft. I'm not so sure if it's already published, but it will help guide us actually, because the role of this strategy plan is to involve all the national government agencies, including the government-owned controlled corporations, and even the local government units to create their own cybersecurity plan. So this is really very much an interagency collaboration among all the government agencies, and also because in the Philippines, CII is actually it's really controlled by the private sector. So we obviously also need to involve the private sector in implementing that plan. Currently, there is a discussion in the UN on getting a legally binding instrument or a norms building one. So I'm not going to go into that, because that dialogue, that discussion is already being done in the US. For us in the Philippines, we're actually very we're flexible on both, but eventually we do want to have a legally binding instrument on cybersecurity. But what we really need is legal capacity and international cooperation, legal capacity building. So currently, we have international cooperation with other foreign governments and international organizations. And that's, I think, what we really need for us to be able to be resilient, cyber resilient, and to also create our cyber capacity. And in terms of capacity building, once the points of contact directory of the OEWG in ICT becomes operational, this is one cyber capacity program that the Philippines can actually use to be able to exchange best practices with other nations. And I do want to mention that one capacity building program that the Philippines take advantage of is the Women in Cyber Fellowship, of which I'm part of. So I'm a fellow, and so it's one of those programs where the fellowship actually's aim is to really encourage more women to get involved in cybersecurity dialogues. And finally, of course, I'm glad, I think it was you, Patrick, who mentioned, or maybe it was Christian, who mentioned about human rights and the rule of law, or probably it was the ambassador, because, of course, the Philippines, as being a party to 9 human rights conventions, we obviously apply human rights and rule of law in cybersecurity, especially when it comes to the individual rights of people.
Great. Thank you, Christina. I think you have done 2 things. One, a wonderful plaque for Canada and the Netherlands, who are the sponsors of the Women in Cyber, together with many other countries, and I'm pretty sure that there are other fellows.
Yes, I actually see some of them in the audience.
In the room. So again, thank you, Canada, Netherlands, and I know there are other countries that are part of that framework that has really contributed to improving the conversation. And since the purpose of this conference is also to acknowledge and identify those programs that actually have very concrete results, I think that needs to go into the notes from the conference. But the second one, and that's the point that I like, we sort of dived very much directly into the conversation about how international law applies, assuming that everybody in the room has the same level of understanding and knowledge actually what it is that we're talking about. So you have done a very nice thing in sort of breaking it down for us. What kind of capacities are we actually talking about? Because we talk about capacities at the individual level, right? So making sure that you have the right people, but also capacities at the institutional level, making sure that institutions actually know how to apply the international law, and there are institutions that actually are sort of providing the oversight of that application. But finally, and that also came up in Ricardo's remarks, we hardly even really talk about capacity building around the enabling environment. And both of you have really stressed the importance of international law as providing this enabling environment for investment and economic growth. And I think that's really something that we really have to think about a bit more. Nana, I will bring you into the discussion. You wearing sort of 2 or 3 hats at the same time, so I let you decide which one you want to put on to answer the question. But I think following on the conversation, you know, and the remarks that Christina made, we have seen a really big spike in the interventions of the African countries in the discussions at the open-ended working group, really on all sorts of different issues, again, partly thanks to the fellowship. We have not really seen many positions coming from the countries, actually hardly any. There is no country that I am aware has adopted a position on the application of international law. Again, not to say that this is the only measure that we should be applying, but how is the debate about international law approach on the continent? Partly as the African Union Commission, but also maybe in different national contexts that you might be aware of. Malabo Convention was mentioned on a few occasions during this conference. Is that the answer? You know, Christine mentioned the Budapest Convention is again another framework that has been established, but also plugged new potential international treaty, which is a big question mark, of course, in the discussion. So where do the countries in Africa stand? Where does the African Union Commission stand in these debates?
Yeah, thank you very much, Patrick, and thanks for the invitation to join this important conversation. You're right that no African nation or country in particular has taken a position relating to the applicability of international law to cyberspace, but as we speak, the African Union Working Group on the common position of the application of international law to cyberspace is meeting in Tunis to come up with a common position on the application of international law in cyberspace. In fact, that meeting started on Monday, and it will end on Friday, and we're hoping that there will be a draft. Now, for the very first time, Africa acknowledged the applicability of international law to cyberspace on the 9th of November, 2022, and that was because of the efforts of the Peace and Security. Yes, and that was because of a commitment from the Peace and Security Council of the African Union, but also the African Union Commission of International Law. So the African Union has this commission on international law, which is made up of scholars, academics, particularly working on international law, which they work on the conventions and treaties and declarations that are relevant in terms of international law. And at that meeting last year, the Peace and Security Council then mandated the African Union Commission on International Law, and I will use the words used, to expeditiously come up with a common position of application of international law in the African context. And so it was like a race, and thanks to Canada, thanks to Liz, I'm so fortunate to sit in between both of them. The African Union Commission on International Law then went to the African Union Commission and said, look, there's a lack of expertise in this area, we need to build capacity. And like I said, Canada supported. There were 3 capacity building sessions this year, in March, in June, in July. And then, of course, like I said, in Tunis, they are developing a common position. And the African Union Cybersecurity Experts Group, the chair, Abdul Hakim, is here, Kalim is here. We also made contributions to that draft statement, and there were also questions on how other member states can contribute. But then one thing I want to say is, the reality is that extant approaches to the application of international law to governance, whether in regional context or national context, will always be reflected in how you approach cyber governance. And this is sometimes a challenge in the context of Africa when you think of the rule of law, democracy, and the issues of conflict in the region, and how we can then prioritize international law principles in terms of how you govern cybersecurity, cyber resilience. And so if you look at, for example, the UNGGE process that led to the norms of responsible state behavior, there was very limited participation of African countries. At the non-paper response, which Canada demanded for, there was no response from Africa. The Budapest Convention, we have only 6 African countries. The Malabo Convention, only 15, but it has come into force. However, that has begun to change. We see overwhelming participation by African countries, particularly civil society organizations, in the open-ended working group. We see at the UN Global Cybercrime Treaty level, Africa chairs the process, and Africa holds one of the vice chair seats, Nigeria, which is impressive. The program of action for advancing responsible state behavior in cyberspace in the context of ICTs has been supported hugely by African countries, particularly Egypt. What this then means is that a document in itself is not prima facie a full representation that international law is accepted as being applicable in cyberspace, whether in regional or national context. And I will say that Africa has taken different approaches. I'm not saying there is no dictatorship or all of that in Africa, but for example, if you look at the Malabo Convention, its preamble reaffirms the commitment of African states to the fundamental freedoms and human and people's rights in the context of the treaties, the conventions, and the instruments adopted within the AU framework and even the UN framework. If you also look at the regional economic communities like SADC, ECOWAS, they acknowledge that international cooperation is a huge age-long principle of international law, and that has guided our approach to developing cybersecurity strategies and principle, working with countries like the UK, Germany. Last year, ECOWAS started working with the German government to develop CBMs, confidence building measures. In August this year, thanks to the UK government, we partnered with them to hold a workshop on confidence building measures for the SADC region. Kristen also talked about how jurisprudence would be a way forward for developing a strengthened position. And I can tell you that the regional courts in Africa have recognized international law's role in developing a jurisprudence for the respect and rule of law in cyberspace. The ECOWAS court, for example, ruled that the shutdown of internet by Togo in 2017 was illegal. The ECOWAS court also ruled that the banning of Twitter by Nigeria was illegal. And also the ECOWAS court has reaffirmed that Nigeria should look at its cybercrime legislation and ensure that it binds or it's aligned to the principles of freedom of expression, freedom of free speech, based on international human rights. There have also been other capacity building measures. African countries are so interested in getting involved in courses. African scholars like courses at the Cyber Law International, the Netherlands Institute for International Relations, the African Center for Strategic Studies that has been building capacity, and coincidentally, the last time I was in Ghana, they were here for capacity building. But the other challenge you see is that there are so many international law scholars in Africa writing. doing research in this area, but most times they are not on open source platforms. So it seems as if there is no acknowledgement in terms of research and academia, and I think that is an area for capacity building. People are actually hungry, and we see that as well with the GFCE ACE project in Africa that has developed, modules on how international law in a way that may not be said clearly, but it's also the case. So we are waiting for that document. And one more thing, the African Union Cybersecurity Experts Group also submitted a document to the open-ended working group last year, and we acknowledge that international law should guide capacity building on the basis of equality and non-discrimination. So finally, before you stop me, Patrick, I know you're about to stop me. We are waiting for that document. It will be presented to the Peace and Security Council in December, and also the Executive Council in February. But I hope that a regional position will indeed mean a regional position, and that it would have the support, it would have that accountability from all the 55 member states of African Union, and they will recognize and respect the common position. Thank you.
Great, thank you, Nana. And a very clear message regarding the recognition of this document from the regional to national level. I also want to echo the important point that you made about open access. I think it's quite important that whenever we think about capacity building projects that don't necessarily focus on human capacity, i.e. trainings, but really whenever there is a research project, for instance, that is funded by different organizations, that there is this component of open access, because I see it very often even in the research projects originating from Europe or the United States. It's a good practice right now to actually budget for open access for any Scholar product coming out of the project. So that's definitely something that would provide broader access to the tools that are and the research that originates from the continent. But there's also Joyce Hackmer, who is the editor of Cyber Policy Journal in the room. I know that their journal has also made a lot of effort over the past years to actually provide a platform for researchers from outside of Europe and the United States, where most of this knowledge is being produced. So for those of you who are interested in producing them, Joyce would be happy to have a conversation afterwards. Please reach out to her. Okay, I would like to make sure that we also have some time for questions, so please start thinking about questions. Yes, I see there's already one, perfect. But hold on, 2, 3, okay, perfect. We still have Lise. I just want to flag to you that we will have the time. Lise, let's bring the practitioner's perspective. Usually we think of the policymakers as practitioners. I think when it comes to increasing the capacities of governments in international law, you're the real practitioner who has really worked probably with almost all governments. Yes, and those of you who follow Lise on Twitter, for instance, on social media, will see that from time to time she's in different parts of the world training regional group here or regional group there. Based on this experience, as much as you can share, could you tell us what are some of the challenges you see? What are some of the priorities that we should be considering, thinking exactly about this theme of leveling the playing field when it comes to international law capacities? But also, if there are countries in the room who are thinking about developing a position or strengthening their capacities, is there any step-by-step approach that you would suggest? Where do they start? How do they start thinking about it? Just to make sure that exactly this effort does not end up with an individual in one of the ministries trained and then disappearing within the system, but that really becomes part of a bigger machinery that leads to more sustainable outcomes later on. So I'll hand you over this one. And I'll try.
Thank you, Patrick. Good afternoon, everybody. So indeed, over the years, in partnership with several governments, the Canadian government, the Dutch government, the Singaporean government, Australian government, American government, we've trained hundreds of government officials. This year alone, I think the count is at 400 or so on how international law applies in cyberspace. But that said, there are many countries that have not engaged with this topic. So if you're asking me what would be my advice for those countries, there are actually two pieces of advice that I would give. The first is understand the relevance of the topic, understand why it is important to apply international law in cyberspace, especially considering that there are in most governments many pressing, urgent topics, and if international law is set alongside those topics, then those other topics seem to be more urgent. So my first piece of advice would be understand why this is an important topic in the first place, and I believe Costa Rica's experience is really instructive in this regard. My second piece of advice would be to understand the geopolitical context in which those discussions are taking place. It's important to be cognizant of why some countries, a handful of countries, are aggressively pushing for this global comprehensive convention that would govern cyber affairs. And it's equally important to understand why many countries are vehemently opposed to this idea. So before countries engage in those conversations about how international law applies in cyberspace, I think it's really important to take a step back and understand the context in which those conversations are taking place. But as for a step-by-step guide, obviously my first recommendation would be to train your government lawyers on this very specific issue. But not just government officials, my advice would also be to sensitize all other public officials whose work relates to this topic, to sensitize them, whether they are diplomats or policymakers, policy advisors, individuals who plan and authorize cyber operations, sensitize all of them to the application of international law in cyberspace, and make sure that they realize that the advice that they give and the decisions that they make are to a greater or lesser extent influenced by international law. Then obviously the next step would be to come up with a national legal policy position on how your state applies international law in cyberspace. And in coming up with that national legal position, the key question is going to be, where do you as a state, taking into account your unique national security interests, where do you as a state believe the red lines lie? Because going through this exercise and figuring out where the red lines lie, you as a state will be much better prepared to react when something happens, like happened in Costa Rica, and you'll be able to quickly determine whether in your assessment that operation violated international law or not. And the other side of the coin, obviously, is that when your state is developing cyber capabilities, is planning on engaging in cyber activities, those activities will be governed by international law. And so it is important to also map out where you believe the red lines lie for your own operations, whether they're conducted into other states or within your own state's territory, which unfortunately is a growing trend in this field. What are the success stories? Obviously, those countries that have adopted national positions deserve recognition because communicating where those national red lines are to the international community does bring clarity to how international law applies in cyberspace. And having spoken with a lot of government officials who have gone through this process, they have all said that it's been a very helpful exercise internally because it presumes that the state brings together officials from different ministries, from different agencies, departments that have responsibilities in the cyber domain, and coming up with this national position requires them to talk to each other when sometimes they might not even know who the individual is who is sitting on the other side of the table, and requires them to also talk to each other when they might approach those issues from very different perspectives and to find that common ground. This is where we stand today as an international community. Obviously, there are many developments happening right now, but I would also emphasize that the story clearly does not end here. Most of the countries that have been active participants in those discussions, they tend to be the more cyber-capable states, the states that normally have offensive capabilities that have been just required because of their where they stand to think about those issues more, and they've come at the issue of international law from their unique perspective. But obviously, we need more countries to engage in this conversation and to really meaningfully bring the conversation forward. Of the success stories, I would mention those countries that have mentioned specific examples of cyber activities that they believe violate international law. So some countries have done that. That brings a lot of clarity to those conversations. And also countries that are transparent about their capabilities to the extent that it is possible, because this also makes this whole discussion about international law, which often is very abstract and might feel remote, it makes that conversation more tangible. And in this regard, probably Australia and the United Kingdom are the best examples. So they've really tried to be as open as possible about the operational reality in which they function. So I'll finish here and hand it back to Patrick.
Great, thank you. We are facing a very, not abstract, but concrete competition from the lunch break right now. So we have to make sure that we don't lose people into other more pleasant activities maybe. I'm going to collect all the questions from the audience. So those of you who have questions, please raise your hand so that I do not miss you. Okay, perfect. And then we'll go back to the panel. If you could introduce yourselves as well and maybe indicate if this goes to any specific speaker or to all of them, please.
Thank you. I'm Cristina Camacho. I work for the Ministry of Foreign Affairs of Ecuador. And I'm just a couple comments maybe to Christine from the Philippines. It has been a very complex process to translate the language of the technical language of cybersecurity to the OEWG, and also in the process of adhering to the Budapest Convention or the UN process for the cybercrime convention. So for us, it has been really a key tool having the support of the Women in Cyber programs funded by the Canada government and the OAS. In Latin America, our 2 delegates are funded, and that has assured this continuity in the delegations. But I still feel this divorce between the rest of the technical institutions in the country and the work diplomats are doing in the UN. So it's interesting to hear your thoughts, and maybe also yours, Liz, on how we bridge this I don't know, translating this language into the technical community in the Ministry of Telecommunications or the prosecutors, and how do diplomats can do a better representation in the UN.
Great, thank you.
Thanks very much. I'm Diego Sanchez. I work at the Ministry of Foreign Affairs of Mexico. And I guess this is an open question, but building upon what Ms. Ifeanyi Ajufo shared with the experience of the common position, I wonder if you have any opinion, or do you think it's going to be useful to insist on the proposal of the International Law Commission at the UN to make recommendations or do a study on how international law applies, which this was a proposal that was put on the table at the open-ended working group, but it didn't mature enough. So I'm just curious about your views about this proposal.
And we can maybe expand this question to others on the panel involved in the process.
Yeah, good morning. Myself, Mr. Norton Roy from Ministry of Electronics and IT, Government of India. My question is actually categorized into two questions. The first one is, what should be the effective approach for a nation to develop and implement the cyber regulations for ensuring safe and trusted device and software ecosystem, especially when these are associated with the CII and the related obligations to be imposed on the OEMs, suppliers and deployers, especially when such nation is largely dependent on other nations where there is also a question of free trade agreements and there is no such legal framework in that particular country that exposes that device or systems. How the international law can intervene and work effectively in this matter, as it is also directly related to the issue of establishing a level playing field for the indigenous developers and OEMs and suppliers, because it is somewhat easier to obligate those indigenous players for observing such regulations, but it is difficult to obligate the foreign or offshore players. The same scenario is also applicable for the offshore social media platforms when it is a question of free flow of information. Do you believe that existing provision of MLAT or covenants and the extraterritorial applicability of the country's particular law and legislations can be efficiently addressing these issues?
Thank you. I'm Ambrose Iena of IDEC Digital, Accra. Looking at international law and strengthening cyber resilience, we have beautiful laws, well woven. The difficulty is sometimes implementation. What are we doing to make sure that local laws in the participating countries are enforced? For example, you have cafes that are operating into wee hours and giving accommodation to scammers and hackers. Whilst people are sleeping, a lot of fraud is being committed on the internet space. And sometimes these are to the knowledge of the enforcers. So I think whilst we are talking law, the law alone will not be useful as long as we don't, enforce. So that is my point there. Thank you.
Great, thank you. I have a dilemma now because there are 3 more questions from the audience. So I'm going to collect all of them. I hope the panelists are taking a good note of the questions that are coming in. So Khalib, Joyce, and Anna Maria, and there we start.
Thank you very much. My name is Kaleem, and I'm heading the Mauritian Computer Emergency Response Team. And again, I'm the part of the African Union Cyber Security Expert Group. My question was, of course, Nina has been talking about the African position and what are the activities are happening in Africa in terms of the adoption of international law, and then our position onto that, how we are looking at it. My question was from the panelists from other regions, that what are the concrete steps that have been taken into their region in order to improve the adoption of the international law, and that has eventually been able to help strengthening the cyber resilience. Thank you very much.
Hi, everyone. I'm Joyce Hackney from Chatham House. First of all, thank you to Patrick for the mention of the journal. So please do come and find me if you are interested in writing a piece for us. And I'm wearing a bright color, so it's easy to spot me in the crowd. My question to the panelists is about the definition of critical infrastructure. As we know, this is one of the main challenges when we discuss the application of international law. The extent of application is the lack of having a common definition of what critical infrastructure is. And we know different countries have different approaches to doing so. So do you believe there is a prospect for making progress on this issue? And if so, what level of granularity should states aim for? Thank you.
My name is Anna Maria Osula. I'm from Estonia, Minister of Foreign Affairs, and good luck for all the panelists for answering all these questions. So you are very brave. I add just a final piece to this task. My question is related with the implementation of legal obligations and related to the gentleman's question about how do we enforce those agreements between states. here we talk about international law, talking about agreements between states, but it is clearly related to obligations within states, so national law. And I think the lady from the Philippines, you brought this out very well, outlining what the Philippines is doing on the domestic level. So as I see it, as from the perspective of the Open-Ended Working Group as well, is this disconnect between those two discussions. Actually, they are very much related. So how can we bridge this gap in these discussions? Thank you.
Great, thank you. And the wonderful thing about collecting all the questions is that the panelists can always choose what they want to answer and what they want to ignore. So actually, that's my gift to all of you. We're almost over time, but we started a bit late. What I would do is ask each of you, I'll give you 2 minutes. You can either answer the question that was asked from the audience or come up with whatever of your own conclusions you want. But please try to address some of the questions. Maybe one of the things that we have not really discussed, but I think, Ricardo, you have also flagged this in your intervention, is the potential role of international law as a deterrent. So maybe that's also something that you want to bring in your answers. And yes, I'll start with you. I was looking at Christian, wanted to start with him, but no, I'll give him time to prepare. Ricardo will go first to you. 2 minutes, please, so that we can finish more or less on time.
Thank you. First, about deterrence, that's very important. And I think international law cannot work as a deterrent alone. It has to come in a more comprehensive system where there's political will, there's also infrastructure that allows to find the guilty parties of malicious activities. So it's not international law by itself that would serve as a deterrent. And I remember having this discussion when I was studying criminal law that in law school, that if harsher sanctions against criminals would deter them from committing crimes. And those laws by itself cannot do it. They have to work in a system that allows to find the culprits. So it's a process, an ongoing process. That brings me to the question about application of or enforcement of international law. I think that's the main question about the application of international law, not only in cybercrime, but in general. I worked for several years in cases before the International Court of Justice, and even the rulings of the court sometimes can be challenged by countries, and there's no practical way to enforce it, but that doesn't make the international law less valuable and less important. And I think we need to keep working in every forum because cyberspace and cybercrime by nature is a transnational space, and it has to be addressed international. So we need to keep working, even if an effort doesn't come to fruition at a specific time. It doesn't mean that it's not a step forward that we need to take. So we have to take those opportunities to keep working and bring other countries to have their national positions, because international law normally works that way. First state practice, then international customary law, and at the end, codified international law. So we have to keep working.
Great, thank you. Christine.
Yes, thank you very much for your question, Christina. From Ecuador. Actually, I'm glad to, well, not really glad, but maybe relieved in a way to know that we have the same problem. Even in the Philippines, there is a divorce between the technical experts and the diplomats, especially in the discussions in OEWG. In fact, very much in those discussions, it's really the Ministry of Foreign Affairs, it's the Department of Foreign Affairs that's really leading the discussion. And we have tried our best to also include our technical experts from our Department of ICT. And that's why I emphasize capacity building, because it is as I said in my intervention earlier, this is what the Philippines really needed. And this is very much, I think, connected to the question in implementation, as well as because part of the plan, actually, the strategic plan of our national cybersecurity strategy is to improve the cybersecurity culture in the country. And in fact, our Department of ICT enumerated several steps on how they plan to do that. Because in fact, in the Philippines, it's been noted that cybersecurity skills is needed, but there is a skills gap. There are not enough people who have the skills to actually implement the laws that we would want to have. So part of the plan of the DICT is to actually work with other government agencies, specifically the Department of Education, so that to include in the curriculum of schools on cybersecurity. In fact, I think they're already doing this cyber hygiene for kids. And also to work with the Commission on Higher Education in the Philippines to include cybersecurity as a degree even in universities, because that's what we really need. We really need a workforce to be able to implement those laws that we really need to be implemented.
I'll perhaps continue along the same lines. I think it's important to understand that a lot of the international law that we are talking about that applies in cyberspace is prohibitive in nature. It tells states what they must not do when they engage in cyber activities that affect other states. And so when diplomats at the United Nations or in regional fora agree that those rules apply, then domestically this does need to be communicated to various stakeholders what it actually means. So practically speaking, what it means is that in Ecuador, in Estonia, wherever, this awareness of the fact that international law, for example, prohibits certain covert offensive cyber operations that have effects in other states, this awareness needs to be communicated to individuals who authorize and approve those kinds of cyber operations. It also needs to be communicated to a minister that orders an internet shutdown, that an internet shutdown is governed by international law and it needs to comply with the requirements of human rights law. Or a judge that authorizes a surveillance warrant, the judge needs to be aware that the authorization of the surveillance warrant is also governed by international law. So this does need to be communicated to the various government officials involved, bearing in mind that a lot of the law is prohibitive in nature. There are rules that require states to act. When malicious operations are emanating from a state's territory, states have a duty to stop them. So clearly those stakeholders that would factually be the ones to stop them, a CERT, for example, needs to know when international law triggers this duty of the state to stop those operations. I'll finish with a note that even though a lot of progress has been made on the international level, the state of affairs is really immature in terms of how the international community deals with violations of international law via cyber means. So today we have some clarity about where the red lines lie, but we've also seen many incidents that, in my opinion, cross those lines, but not too many reactions. There aren't too many reactions that we've seen that are based on international law. Even the most basic of reactions, which is condemnation on the basis of international law. So there is a lot of room for improvement for the international community as a whole. And for me, the obvious next step is how to deal with violations of international law via cyber means, now that we sort of kind of have an idea of when those violations occur.
I will just agree with Liz and continue from there to say that indeed, yes, there is so much immaturity. This year, there was so much cyber attacks in Africa. The African Union Commission was shut down for over a month, and Kenya and other countries suffered attacks by a group which called themselves Anonymous Sudan. And there were questions of how do you relate to cyber attack in the context of international law, armed attack, non-state actor and state actor responsibility and attribution. And that is why I agree that there should be a position that mandates national positions, and agreeing with Anne-Marie that sometimes it's more of a detachment. So I agree that the International Law Commission should come up with a position. And I say this because, particularly in an African context, if you do not mandate national positions that adopt the applicability of international law to cyberspace, we will continue to see violations of rights, violations of international law mandates, and national security will continue to be an alibi for what I call irresponsible state behavior in cyberspace. That is what we tend to see. The other issue is that there is a divergence in provisions in cybercrime legislations. I'm trying to remember. So the point that was raised about differences in Joyce, the point that was, forgive me, the point that was raised about the differences in definition, for example, critical infrastructure. You would see legislations in Africa, for example, that use cybercrime acts to punish genocide, crimes against humanity, and it's embedded in critical infrastructure and attack on critical infrastructure. So it would be good to have an international law commission position, but like Christine has said as well, Ricardo has said, and Liz, let's mandate national governments to come up with position. We have a Malabo Convention. Only 15 countries out of 55 countries have ratified. So if you have a common position, what is the guarantee that other countries would accept this common position? So I'm all for ensuring that national governments abide by their obligations under international law treaties, and at the same time come up with a position that voices a clear and unequivocal respect for international law applicability in cyberspace.
Great. Last word. Last before lunch, or do you have the last words? Two quick comments. One, I don't think there is a single kind of unified understanding of what international law means and how it applies right now. We've been, and Ambassador Norman's made that point, you know, he said understanding. Oh, closer. Okay. People have made that point that, you know, understanding's plural. We don't want to force, you know, a unified understanding right away. I think, you know, over time it's going to happen. That's a normal process. You know, you see where you diverge, where you don't agree, and then you shape up. Second point, 100% agree, Christina, with it's hard to go from UN speak to technical speak. I think, you know, if you think about the framework as a whole, we very much recognize that, and we're trying to bring it down. Like, you know, efforts such as norms guidance is very much aimed at that, as saying, okay, let's go from general statements that can be interpreted into many ways into what does it mean in practice. And I will say one of the most kind of surprisingly but insightful conversation I've stumbled into is a situation where I was sitting with my MFA counterpart from a different country, and our two certs were in the room. And then talking in this kind of, you know, square format about, okay, here's what we're talking about at the UN, here's how you're doing your cert business, was just fascinating just to see all the different ways that it gets interpreted. And I think that can be a very productive conversation.
Great. Thank you very much for sticking to your assigned time. I will not sum up the panel. I think there were very many interesting nuggets. Please think of this panel as a conversation starter. The panelists are here still at least until this afternoon. So if you have any questions about international law, please do reach out to them. I'd like to end with the word of thanks to Camino Kavanagh, who was session lead from the program advisory team and put this wonderful panel together. I'm just stepping in as a moderator, but she deserves all the thanks for preparing this. And of course, once again, big thanks to the co-leads and our panelists for giving us a lot of food for thought. So please join me in helping them, in thanking them, and then we can all transition to lunch. We also have a very small token of appreciation for the organizers for intervention. So thank you very much, everyone, for joining us, and thank you to the panelists.